public support? Or are you looking at that? What is that? Okay, I can do that for you, that's no problem. Are you more comfortable with
Yeah.
state or federal court?
Oh my goodness.
Are you guys doing, redrafting any demand letters initially?
I can see it's gonna be a long night. I ain't gonna stop till I get it right. I don't wanna sing no Jeremiah. I'd really love to say things just ain't that bad. Oh, how we love our denial, a comfort to cover up the shame. But the truth is standing on trial. And I've got proof that we're all to blame. Oh, my fellow Americans, are we reaping our harvest of greed? Have we built our house on sinking sand? Why are we being ugly Americans?
Good morning. This is CJ, founder of Homeowners for Justice, and your show for today, host for today. And I'm sorry, I'm going to have to stop the sound coming in. We've got Joe on the webinar, but it's making too much sound. So anyway, turned off the microphone, I believe, so that we can actually focus without hearing the sound in the background. We've got him on the show today. He's going to really explain a lot of the information that we need to understand, the words. And then we've got Charles Wallshein joining us today also from New York. He's our go-to attorney right now and really working hard to kick this movement into the next level. And that's what we need. So we're working with him, we're pushing, and we just thank both of them so much for joining us. But before we start, I want to talk about a couple of major things going on. There's always something going on every day. That's why I decided it had to be weekdays live. Every day something else is changing. And the first thing we're going to talk about is all these teeny payments going out to people that were wrongfully foreclosed. It is just absolutely an outrage to me that they can even say these words, that they were wrongful foreclosure. They took these people's homes. They ruined their lives. They've destroyed their credit. They're probably living in a tent or under the bridge. And then they're going to give them, $800. Some insane amount. And that is just truly outrageous. And then you just got to hear these people. They're talking about the hedge fund and all of these market investors and how basically they don't know what they're doing either. It's just a big gambling casino, and that is the point. So here, robo-signing victims soon to get cash payments from the lenders. Well, maybe. And it says from a few $100s to maybe $125,000 beginning in April. That's the OCC saying this. And they're the ones, the OCC are the regulators that said, oh gee, let's just have the banks figure out who they should pay. We can't figure it out. And if you look down in the article, they've already spent $1.5 billion in fees to the consultants. But only 104,000 loan reviews have been done. Oh my goodness. Talk about a money scam. I swear to you, with just those facts, we have to conclude that the independent foreclosure review companies were the shell game, corporate shell game. Those banks made corporations, called them independent, hired them, funneled the money to themselves. What else could we expect? That is the outrage. Here's just a real typical one little example of, and multiply this by 9 million, 4 million for sure that have already been foreclosed. Tons of short sales that those owners lost their homes, down payment and credit also, and can't borrow. And now we've got millions more in the pipeline. In fact, every owner in the country now has a broken chain of title. Nobody knows who owns the loan. Nobody knows how to pay it off. If you make your payments, nobody knows if it's really going to pay off the loan or not. And in the end, you make your payment and you pay it off, and then you get foreclosed. That's happening all over the country, and the homeowners must rise up and stop this, joining with the attorneys. Let's listen to this.
Homes in Pompano Beach don't get much more American than this, and Paula Lawler has always been proud of her house. She's raised 2 children here and wants nothing more than to stay.
Hi. Hi.
But when Paula got sick and missed a mortgage payment, the banks moved in and began the foreclosure process. 5 years later, she's still fighting it and still in limbo.
I have repairs that need to be done. The tile needs to be fixed. The roof has a leak, I guess.
Paula isn't behind on her payments. She's willing and able to keep them up, but says the banks have no interest in taking her money.
And here I am, a single mom, hardworking, 2 kids, raising them, and I just want to stay in my house, and just not happening for whatever reason, So sorry, I get emotional.
For North America's big banks, Monday's settlement is essentially an admission that they mishandle mortgages on a huge scale, forcing many families out of their homes. People who were unfairly foreclosed on could receive up to $125,000. But critics say the deal allows the banks to escape responsibility for damages that could have cost them much more. And lawyers like James Bonfiglio think the compensation is little more than a token gesture.
It really doesn't do anything because it's not going to stop the foreclosure process. It does nothing to force banks to modify these mortgages. It does nothing to keep people in the houses.
For the banks then, this has been a chance to wash their hands of what's been a messy mortgage crisis and move on. After this announcement was made, shares in many of these institutions rose sharply. But for millions of homeowners still struggling to pay or even modify their mortgages, this represents very little, if any, real help. Andy Gallagher, Al Jazeera, Pompano Beach, Florida.
No kidding. No kidding. That is the point. They call it a messy deal. No. This was a theft. They stole these homes. We know that because we know they broke the chain of title. That is the point. Not only on those they've already foreclosed or those they're going to foreclose, but all the rest of the owners that eventually will be foreclosed. This is the crisis. Your neighbors need to understand right now that even if they are current in their loan, there's no guarantee. There's no guarantee because they ruined it. Everybody's chain of title in this country is now destroyed. There is no guarantee that even when you make your payments, Linda just said yesterday, they keep 2 sets of books. Are you kidding? So with 2 sets of books, it's over. The game is over. The homeowners must rise up. And we're talking about how we're going to bring this to the media attention. The disclosure of forged documents or the suspicious documents, all of this is really good effort, but, we're trying to attract a backer. We need to have something more powerful and more immediate. So let's just pay attention to some of these other things. We've already touched on them earlier this week, a little bit last week. It's all about Cyprus. It's all about the money. And it's all about the Fed, who's just pumping credit willy-nilly into the atmosphere, I guess. It feels like a huge mushroom cloud of now trillions or quadrillions or pick a really stupid number because it doesn't make any sense anymore. It's really stupid. And here is just right now, this was published just April 1st. What is that? Yesterday. The U.S. economy is in a bubble inflated by phony money from the Federal Reserve and will burst in a few years. There you go. I think that sums it up. You can read the rest of the article. The fact is, we already know they're manipulating real estate prices. The banks have millions of homes that they are in their vacant foreclosure inventory they are not listing. And so I've actually, for several different clients, have now counted how many vacant foreclosures there should be just from my records. How many did they take over these years? How many have they listed and sold? And the fact is, generally, in many of these places I've counted, they have about 50% of the annual sales in that area held back. So, for example, you take Vallejo. They have the city of Vallejo in Solano County sells approximately 1,890 homes a year. They did that for the last 2 years, and the bank has 1,000. The banks have 1,000 vacant homes there. So when the banks are holding back about 50% of the sales in this country in their reserves, then they can make a break a market just like that. They can say, dump these listings, poof, and if you thought home prices rose, they will collapse. So this is what we're sitting on, and part of this is the Fed is fueling the bubble to keep from depression and this collapse, and the banks are saying, okay, let's hold on to these as long as possible, and let's shove them off at a high price to these hedge funds. Let's do something with them, and eventually, though, we know that what goes up comes down. Bubbles pop. That is the answer. Here is just a brief, just a few minutes. They're talking. This is an analyst talking about how the stock market sort of really works because of the people involved. I found it very enlightening, a little bit on the scary side.
All right, so before the break, we covered Bank of America, but what about the financial crisis legacy? How much of that is being felt more broadly in the banking system, and how much has to be worked out still in the form of litigation or layoffs? More with Heidi Moore, Marketplace Wall Street correspondent and New York bureau chief.
So much. I mean, if you look at, you can measure the losses. There are the actual lawsuits or class action lawsuits and the potential charges they have to take on those, that the banks have to take on those. But really, look at how much they've lost in their stock price. Look at how much they've lost in their book value. When banks have lost so much value that Sandy Weil, the father of big banks,
right,
is saying they're not making enough money to survive anymore, let's break them up, then you know something has really gone wrong in the industry. And the question is, do they recognize it, right? I mean, this is the big debate. Do people within the industry realize that it really does have to change? Or do they think that right now it's just kind of a cyclical moment, things aren't so great, and they'll be able to go back to making money in the same ways and with the same incentives that they had in 2008. And that will tell you everything about the future of the banking industry.
What do you think is the answer to that, just judging on the reporting that you do? What do you think that people within the banking industry think? Because we have the Sandy Wiles, but we have the Jamie Dimon saying bigger is better. That's misguided.
Right. Well, Jamie Dimon has to protect his stock price.
Right.
So
yeah,
God bless him, because if he came out and said anything other than what he said, people would really worry.
Right.
But I think that there are an increasing number of people who are dissidents to the way that the financial system works. They're within the financial system, but they're like, this is not working. And maybe it wasn't working before, but they were able to make money from it. Like, you could still push that engine forward. And now it's kind of the gas is out of it. It's barely chugging along. And they're coming around and saying, you know what, maybe we should look at a different way of compensating people, or a different way of setting incentives, or a different way of looking at lending. Because what's obvious to probably the rest of the populace, and maybe not to the people doing much of these jobs, is what happened before was not working. Like, you can't go back to that system and expect that system to be profitable.
We were talking earlier about just how the financial media's role in this, and how the landscape has really changed, in the sense that I think post-financial crisis, maybe there's more of a taste for investigative journalism into the banking industry, and we've seen more blogs, and the Twitter sphere has exploded. So how do you think that landscape's changed, and how do you think that changes the information that we know? We were talking about the Merrill Bank of America acquisition. Would we have had more information sooner, do you think, now than we did then with subpoenas? Do you think that it would have come out in the Twitter sphere or something?
I think that's a really interesting question. I have to say, I don't see too much secret subpoena type information on Twitter. I'm a pretty big tweeter.
Yeah.
What Twitter is really good for is like you get information instantaneously.
Right.
So, instead of, I was at the Wall Street Journal at the time of the financial crisis, and I remember, you could look at the Dow Jones newswires and see what was going on, but really you had to have the Dow Jones newswires or the Bloomberg wires or Reuters at your desk. If you were, an average citizen, you were not going to get a breaking news alert, that Lehman Brothers had failed on Sunday night. Like, you'd have to go specifically to the Wall Street Journal website or the New York Times website to look for that. Whereas with Twitter now, within seconds, every piece of information, whether it's Whitney Houston's death to the Bank of America settlement to, QE3. Right. So obviously the speed of information is much faster, and there's so much more there for you to look for. But Twitter is not an investigative tool.
Right.
And so I don't think it would have put us in that much better sort of a mindset to be able to understand what happened in the financial crisis, because that is where investigative journalism, where making the calls, where digging deep helped a lot in setting some of the narratives before the subpoenas came in even. A lot of the reporting that was done at that time was really accurate and important before the government even started sending people into these banks to take a look at it. And everyone at the elite reaches of banking and finance and government were worried that anything that they would do would topple the whole system over. I mean, it was reporters who were working hard to get that information out there and try to create the narrative that we still talk about of what just happened.
Right. And just because we're talking about how the banking system has changed, profits falling, all of this, before we go, are traders, is the financial industry looking for ever more creative ways to get ahead? Because you wrote an interesting piece about astrology being used.
Yes.
Is that, are these the measures that people need to resort to now to try to return to that era of profitability?
What's really funny about that story was so much fun to do, and talking to people who are financial astrologers or who use financial astrology is, it is not new. It has been around since the 40s and picked up a lot of popularity in the 60s and then obviously in the 70s with the whole sort of, hippie era. But what was really interesting was after the crash of 1987, one of the astrologers told me that a whole bunch of hedge funds bought financial astrology software, kind of on the down low, and they didn't talk about it. He doesn't know if they ever ended up using it, but people in finance, right? Mm-hmm. Anything that gives you an edge. It doesn't mean that they are going to be faithful to this one way of seeing things, that they are going to, check the Fed's horoscope before making any of these decisions. But as somebody told me, a 28-year veteran of Bear Stearns told me, if you're a trader and somebody tells you the market's going down in September, it goes down in September, it doesn't matter who that person is. You're going to go back and ask, what's going to happen in November? Tell me what you see. Totally. Because you never really know. I mean, the market is almost in itself a mystic occurrence, a mystic phenomenon. And as one of the first things that I found out when I was a financial reporter and I had just started, I would read the stock market stories and it would say the market is up today because, oil and Afghanistan and Iraq, like all these really elaborate theories. And I was like, wow, these people must be really smart. But they understand how these geopolitical things cause a change in the Dow. I don't know if I could ever wrap my mind around that. And then, of course, you become a financial reporter and you realize basically everyone's guessing. And it's not you as the reporter who's guessing, it's also the people in the market who's guessing, and everyone's taking the most plausible theory. So if you look at financial astrology through that lens, that it's just one more theory for them to go through, then I wouldn't be surprised. I mean, they do have thousands of subscribers.
That's so interesting. It
so
makes
it was
sense.
fun.
Bring in the mystics.
Bring in the mystics. Are the professionals doing much better? Now everyone's going to be mad at me for saying that.
Oh, well, we'll cut that part out. No, I'm just kidding. Thanks so much, Heidi.
Thank you.
So there you have it. The market is a gamble house. And I just wanted to point out some things that really struck me of that interaction. One is the denial, bank denial, market trader denial. They are going to deny that this could blow up until it blows up. And then they'll look back and say, well, why didn't we know it was going to blow up? And the fact is, they should be knowing it's going to blow up. If they're watching live stream with us, they know. And this is the point. I'd also beg to differ a little bit, because I know that the trillion trades, or however many stupid trades the computers do, where they're arbitraging every little trade hundreds of times, the computers from Goldman Sachs, they are between the people doing the trades and Goldman Sachs, and they're leveraging just fractions of a penny off of every trade, pulling in gobs of money. I would propose, I would say that probably does help affect the market in the favor of the banks and the house, if you will, the gambling house. But nevertheless, it's very instructive to hear these people that have been on the financial beat a long time and talk to, well, Bear Stearns isn't even in existence now, about the fact that nobody knows. They don't know either. It almost feels like they've mounted a beast and they're just riding, 100 miles an hour. They don't know where they're headed. And this should give us all pause. So today, I want to bring Joe on the on the show. Hi, Joe. I've turned your mic back on. Sorry, it was just a little noisy. We could hear it on the live stream.
That's okay. It's quiet in here now.
Oh, good. Okay, thanks. And before Joe starts, I'd like to show the disclaimer, because Joe's going to be sharing with us information. But this is he's calling it legal education. It's not the same as legal advice. The application of law varies within an individual's specific circumstances. We recommend you consult a lawyer if you want professional assurance that this education information in your interpretation of it is appropriate to your specific situation. Joe is not offering legal advice, nor is he licensed to do so. And I might add, neither am I. I'm a licensed real estate broker and I handle transactions. I don't do loans. I don't do foreclosure defense, but I'm really a voice to share with everyone as much as we possibly can. What is going on? What are the options? What actually has happened? And Joe is bringing to our attention today some really interesting information. So Joe, could you please sort of summarize up front what you're going to talk about, and then we'll then lead the discussion.
Sure. Today we're going to talk about negotiable instruments, specifically about the tangible promissory note. So I've heard a lot of misinformation out there in regards to what is being claimed by the banks as bearer instruments, when in fact they're actually order instruments. So what I'd like to do today is to just clear up the air and bring people out of the hole of misinformation.
Okay.
So when we talk about instruments, the banks many times refer to the tangible promissory note as a bearer instrument.
Right.
I have it. The banks claim that there is a, quote, in their words, a endorsement in blank, and because they are the bearer of the instrument, it's a bearer instrument. That could not be further from the truth. So what I've done is, we've got a few examples. The first two that are up on the screen, the first one is from the County of Rockbridge, and it says for 10 cents, we'll pay to the bearer of the office of the county treasurer 10 cents. Again, it says, we'll pay to the bearer. The word bearer is spelled out. The second document is one that is a generic creation, and it says, the all-new bearer instrument, payable to bearer upon demand. Okay, now, let's go down to the next instrument. There you go. All right, now, these are copies, so you cannot cash them. But in both of these documents, these are promissory notes. These are Federal Reserve notes. And it says, at the top one, which is a $100 bill reserve note, at the bottom of that it says, pay to the bearer upon demand. Now it's covered up by the bottom one, which is a $10,000 Federal Reserve note, and you see that it's circled in red. pay to the bearer on demand. Again, the word bearer is spelled out. So now, step up further. In each of the states that we have, type of commercial code has been codified. So whether you're in Louisiana, Georgia, or New York, each state has their own specific instance of the Uniform Commercial Code. Now, if you're in the state of New York, sure, you're going to use the 1961 version of the Uniform Commercial Code. However, the majority of the other states, again, the verbiage is very similar. So let's just take the UCC as a whole. If we were to go to Article 3-109, it says payable to bearer or order. All right, so this is going to tell us what is order paper, what is bearer paper. So a promise or order is payable to bearer if it, 1, states that it is payable to bearer or to the order of bearer, or otherwise indicates that the person in possession of the promise or order is entitled to payment. Okay, 2, does not state a payee, or 3, states that it is payable to or to the order of cash, or otherwise indicates that it is not payable to a identified person. Okay, now we go to 3B, that is not payable to bearer, payable to order if payable to the order of an identified person or to an identified person or order. A promise or order that is payable to order is payable to the identified person. And we go to C, which says an instrument payable to bearer may become payable to an identified person if it is specially endorsed pursuant to Section 3205A. An instrument payable to an identified person may become payable to bearer if it is endorsed in blank pursuant to 3205B. But again, it's talking about payable to bearer, B-E-A-R-E-R. So on the document, if it does not state payable to bearer, and it says pay to the order of, it is order paper. In these samples that we have, every single one, it states will pay to the bearer. All right?
Okay, so Joe.
So in order for you to cash it, or again, it needs to be stated, pay to the bearer.
Should I go to
All
those
right.
should I go to those endorsement samples?
Not yet. We're gonna get to
okay.
that. All right, because one of the things that the banks are talking about is that they have a instrument that is endorsed in
Right.
blank that is bearer paper.
Exactly.
All right.
Exactly.
So right now, so we're going over the difference between bearer paper and order paper. So if you just scroll down a little bit below the next one, you're going to see the difference between pay to bearer and pay to the order. So scroll to the next slide below
Okay.
there.
We'll pay the
Uh,
bearer.
go-
That one. That one?
All right, this is bearer paper. Again, we're talking about bearer will pay the bearer. So if there is not a name, all right, then it says bearer.
Right.
It is not unnamed. So when we've been so indoctrinated to believe
Right.
when somebody uses the word blank, I
Right.
use an example. If you're going to take a test and the person giving you the form says, on this form, there are many blank lines. Okay, you say, okay, it's blank. Blank means that it is not filled in.
Right.
Okay? So again, it's word crafting at its finest. So again, payable to bearer, okay, and pay to the order of, two completely different types of instruments. So if it says
Right.
pay to bearer, fine, then it is bearer paper. but I have yet to see a single note out of all of the thousands that I've seen that have the words pay to bearer. Every single one says pay to the order of. So when we go to UCC 3-109, it's very correct. When it says pay to the order, this is order paper. It's self-explanatory.
Right.
So, all right, so now we know what order paper and bearer paper. Now let's talk about endorsement, because what I've heard a lot of people are saying, Joe, this is bearer paper with a blank endorsement. Well, what is a blank endorsement? First, we have to talk about what is an endorsement. All right, so if we were to go to UCC 3-204, all right, it says endorsements. So, endorsement means a signature, other than that of a signer as maker, drawer, or acceptor, that alone or accompanied by other words is made on an instrument for the purpose of negotiating the instrument, restricting payment of the instrument, or incurring the endorser's liability on the instrument. But regardless of the intent of the signer, a signature and its accompanying words is an endorsement, unless the accompanying words, the terms of the instrument, and the place of the signature or other circumstances indicate that the signature was made for a purpose other than endorsement. So, without a signature, there is no endorsement. Now, a blank endorsement consists solely of your signature, your name, John Doe, C.J. Holmes, Sally Brown. That is a blank endorsement. Now, again, we've been so indoctrinated to believe that these lines are blank. No, they're not blank. They're unfilled. They're incomplete. So we need to change the information that's going into the brain. So when the Uniform Commercial Code says that endorsement means a signature,
Yes.
all right, well then that is an endorsement.
Right.
Without the signature, there is no endorsement.
Right.
All right, so now when we go to UCC 3205, which is special endorsement, blank endorsement, and anonymous endorsement, okay, it talks about if an endorsement is made by the holder of an instrument, whether payable to an identified person, again, payable to an identified person, or payable to bearer.
Right.
Okay, again, that's the word is spelled out, B-E-A-R-E-R. Okay, and the endorsement identifies a person to whom it makes the instrument payable. It's a special endorsement. When specially endorsed, an instrument becomes payable to the identified person and may be negotiated by the endorsement of that person. And the principles stated in section UCC 3-110 apply to special endorsements. So when we say pay to the order of, that is a special endorsement. All right, so we're naming, all right, this is a specific instruction I am giving you. Pay to the order of.
Right.
Okay, now, if an endorsement is made holder of an instrument and it's not a special instrument, it is like endorsement. Again, if an endorsement means take the word endorsement and put the word signature. So if a signature is made by the holder of an instrument and it is not a special endorsement, it is blank endorsement. When endorsed in blank, an instrument becomes payable to the bearer and may be negotiated by transfer of possession until specially endorsed. So I'll give you an example. When you have a check, and everybody does this millions of times a year, you have a check and you fill it out. However, when you fill out your check, you don't put, it says pay to the order of, and you don't put in the payee name. So you put date, you put the dollar amount, and you go to the bank to cash it. because you need cash and you don't have a debit card. Now, when you go to the teller and you present to the teller, what does the teller do? The teller says, excuse me, CJ, there is no identified party to fill in your name on the payee line. You say, no, I don't feel like it. Just give me the money. No, I'm sorry, CJ, but we need to have a name on the payee line. How do we know who to pay? All right? Otherwise, we can fill this in 100 times.
Right.
All right, so then, CJ, you put your name on the line, and it says pay to the order of CJ Holmes, and you back to them, and they give it right back to you, and they say, excuse me, but we need to endorse it.
Right.
So now CJ says, well, I don't feel like it. And they say, well, sorry, we can't do anything because it's not perfected until you sign it.
Right.
So now CJ signs it, and that is a blank endorsement, and they say, excuse me, CJ, I know you've been coming here for 10 years, but I need to see some identification. Because when we look at 3205A, it's about payable to an identified person or payable to bearer. Now, if CJ would have written the word bearer, B-E-A-R-E-R, on the check, okay, she was the bearer of the instrument. Now, because it said paid to the order of C.J. Holmes, and C.J. Holmes signed it back with a blank endorsement, she then had to identify that she was the individual who was presenting this instrument for negotiation. Okay, now, C.J., sometimes you have this check, all right, and when you endorse it, all right, on the you'll write for deposit only.
Right.
All right, now that falls under UCC 3206, restrictive endorsement, where you for deposit only or payable without recourse. All right, you're placing restrictions. So 3206 reads, A, an endorsement limiting payment to a particular person or otherwise prohibiting further transfer or negotiation of the instrument is not effective to prevent further transfer or negotiation of the instrument. Or B, a restrictive endorsement is an endorsement stating a condition. So when it says without recourse, you're stating a condition. You're giving a set of instructions. So now when we're looking at a promissory note and there is a stamp, and that's what it is. It's an incomplete set of instructions. Now, we understand the intent, pay to the order of. All right, so the intent was to negotiate this instrument. However, until the payee name is named, negotiation cannot take place, and we'll get into that in a few minutes. So, when the bank comes forth and says, I have a blank endorsement and this is bearer paper, excuse me, but it says pay to the order of, and then it is an incomplete set of instructions. It's not hard. We just need to take it apart and look at what does the Uniform Commercial Code actually say. Now, California has their own, New Mexico has their own states, Louisiana has its own, but they're all very, very similar. Because remember, hundreds of millions of dollars are transacted every day. And the whole point was to have a uniform way to transfer and negotiate instruments as readily as cash. So we cannot say what a blank endorsement is just because we wish to change the words, even though the banks do. So under the Uniform Commercial Code, that says a blank endorsement consists of a signature. A special endorsement consists of a set of instructions. A restrictive endorsement will, again, further restrict the actual action. So when there is a stamp that says pay to the order of, and it stops, it is an incomplete set of instructions. No negotiation, transfer, or delivery can take place until the party is named on the payee line. So What we need then to do is we need to get in and we need to talk about, because the banks are always saying, well, we've for this, we've sold this. What constitutes a transfer of the instrument and what rights are acquired by the transfer? Because CJ, all this is about, it's all about rights. That's what title is.
Yes. Right.
Okay, so in order to have a full cause of action and not a partial cause of action, all right, and many times there's only a partial cause of action when there is only an purported assignment of mortgage or purported assignment of deed of trust.
Right.
You know, you can go back as far as Carpenter versus Logan, which is, I believe, 1872, which states a mortgage without the debt cannot survive a moment. You know, the entire instrument consists of both tangible and intangible. It consists of the tangible promissory note, the tangible security instrument, which is a separate contract which provides an alternative means of collecting. And we also have the intangible payment obligation, which is the right to future payments.
Right.
And that is the entire instrument. So unless we have a party with sole interest in all three, and that does not happen a lot.
Right.
So if we go to UCC 3203, it talks about transfer of instrument and rights acquired by transfer. Now, A talks about, it defines the transfer. An instrument is transferred when it is delivered by a person other than its issuer for the purpose of giving to the person receiving delivery the right to
Force. Uh-oh.
enforce. The instrument is transferred when it is delivered by a person for the purpose of giving to the person receiving delivery the right to enforce the instrument. All right, so now it's defined. So now let's look at B, C, and D. Which, all right, so B says transfer of an instrument, whether or not the transfer is a negotiation, vests in the transferee any right of the transfer to enforce the instrument, including any right as a holder in due course. But the transferee cannot acquire rights of a holder in due course by a transfer directly or indirectly from a holder in due course if the transferee engage in fraud or illegality affecting the instrument. Now let me ask you, CJ, has there been any fraud out there in this industry?
There's been a whole lot of
Because if there is,
stuff.
I'm just saying, if there is, well then 3203, all right, says that negotiation cannot take place.
Right.
If we look at 3203C, which states, unless otherwise agreed, if an instrument is transferred for value and the transferee does not become a holder because of lack of endorsement. Let me read that again. Unless otherwise agreed, if an instrument is transferred for value and the transferee does not become a holder because of lack of endorsement by the transferor, the transferee has a specially enforceable right to the unqualified endorsement of the transfer, but negotiation of the instrument does not occur until the endorsement is made. Okay, so again, until the endorsement is made. It's black and white.
Right.
All right, so now if we go to 3203D, as in dog, if a transfer purports to transfer less than the entire instrument, negotiation of the instrument does not occur. The transferee obtains no rights under this article and has only the rights of a partial assignee. So now, when we're talking about transferring the note, and then we would do an assignment of the mortgage,
Right.
and then again we would have the intangible payment obligation. So if a party purports to transfer less than the entire instrument, then negotiation does not take place. So if one would only strip out the intangible payment obligation and sell it, which is legal, they can do that under Article 9 all day long,
Right.
that's fine. However, once they do that, negotiation of the instrument does not occur.
Yep.
All right, so example, if a party has, I use me, all right, so our loan that we had was purported to be sold to Fannie Mae. Now, what did Fannie Mae buy? Because if we look at Kemp versus Countrywide on page 14 of Linda D. Martini's deposition, she states, Countrywide is in the business to sell rights, not sell notes.
Right.
All right?
Rights to
And
the
if you
payment
read
stream.
further within,
Yep.
right, Fannie Mae documents, which I have all the manuals, all right, it states specific procedures. The note is never endorsed to Fannie Mae. An assignment,
Yeah. I apologize. We're having trouble with the
while
sound.
it looks like an assignment, so it's done in recordable form, all right, and if you look at the collateral, it's in there, but it is never recorded into public.
Right.
So what has Fannie Mae purchased? Fannie Mae has purchased the right to collect future payments,
Yep.
and that's legal. However, while afforded a temporary perfection under the UCC, it has the limit is 20 days. So for the first 20 days, they're afforded a temporary perfection of the tangible instrument. However, on day 21, that security interest becomes unperfected. And while these purported documents, the tangible promissory note, is now personal property of Countrywide. And this is why when Bank of America comes forth and they claim we are the successor in interest to BAC Home Loans,
Right.
successor in interest to Countrywide Home Loan Servicing. Well, yeah, in February of 08, they did a portfolio buyout and they acquired certain personal assets. Okay, so these assets happen to be documents and papers with writing on them.
Right.
All right. So now Bank of America, yes, you have personal property, and this document says it's a promissory note. However, simple possession with no rights is not the same as possession with legal right.
Exactly.
All right. So, all right, you own a piece of paper. The dollar value is worthless because the payment intangible stream has been ripped out and sold. All right, thus reducing the value of the security instrument. And with no debt to attach to, this security instrument becomes a nullity.
Right.
All right? If I've sold the rights to receive future payments, all right, they're no longer attached to the note. So now 10 years later, Bank of America has the note and they say, I've got the note.
Right.
Good, whoop-de-doo. You have simple mechanical possession with no rights.
And they are
You have personal property.
And they are confusing that with bearer paper,
Correct.
which would give them the full rights.
Correct. Again, if a transfer purports to transfer less than the entire instrument, negotiation of the instrument does not occur.
Right.
All right, now, if we go into the official comments, all right, of the Uniform
I apologize.
Commercial Code under
There
section,
it is.
comment 7 of the official comments reiterates that until the endorsement, so let's just take out the word signature. So until the endorsement is made, the purchaser does not become a holder. And if he receives earlier notice of defense against or claim to the instrument, he does not qualify as holder in due course under section 302(1)(c). So again, it's saying until the endorsement is made, you cannot even become a holder. So it's just a lot of word crafting that is being done.
Now, Joe, here's a just a sec. Here's a question I've got, and I apologize right now. We're having some audio trouble, and I'll work on that for tomorrow. Sorry, guys. We keep trying new stuff, but Joe, thank you so much for sharing this with us. Now, my question is, you are quoting the statutes. This is the Uniform Commercial Code, so every state has something like this somewhere.
Yes.
And could easily, relatively speaking, be found by researchers. And so have you been able to take these facts and help them be incorporated into any lawsuits to help owners, stop foreclosure and keep their homes? Have we gotten to that point yet?
Yes. We use statutory requirements of law in the chain of title analysis that we do with mortgage compliance investigators, using the same arguments in addition to other requirements of law. I've discharged the obligation on my house over 2 years ago. Now, a lot of cases that are today, they're using arguments correctly, but it's only been recently they've been able to articulate the correct argument.
Right.
So many times it's a generic version of the argument that the courts are hearing, and this way there are so many bad case citations out there, and it's in Nevada, Arizona, California, New Mexico, everywhere. All right, because the correct argument was not articulated, we have a lot of bad case law to overcome.
Exactly.
Because we had a lot of parties doing so-called audits, and in fact it was cursory information. If the parties get the information of what was to be done, what was not done, and what was done according to law, it's a lot easier to beat the banks.
Right. So
but again, they need to have all of the information.
Right. And so now with better citations and if you will, just an expression, a better pleading, we ought to be able to overcome some of these bad rulings for homeowners in the future, and possibly go back for those that have already lost homes to foreclosure and help them get remedies. Wouldn't that be the case? Couldn't they prove these issues in past foreclosures?
Right. Again, it depends on the requirements of law for the state. However, I can tell you this, that there are a number of cases that we do have that specifically state what is a bearer instrument. We have cases from Alaska, U.S. Supreme Court, Florida. So we have numerous cases that we can bring up, which specifically say these are the requirements for bearer paper. This is a requirement for order paper.
Right.
So even though a bank says, well, this is standard operating procedure, all right, if it does not comply with law, it's against the law. There's a case out, USA versus Hibernian National Bank, where the courts found that the banks were in error just because they said that they do a certain procedure this way, that it's so. The courts ordered, well, it's not so. It's against law.
Right. And just like Charles has said, he's going to be on the show real soon, but he basically said just because in all of our deeds and trust and mortgages it calls MERS the beneficiary doesn't make it so. And that's,
correct.
That's the same concept here with these. Just because the banks and MERS attorneys and everybody says it's bearer paper and that gives them all the rights, what Joe is explaining to us today is it's not true, and yet the people have to push that. obviously no one is stepping up right now on behalf of the people as a whole to save the homes and to enforce these statutes. Hey, Joe, can you explain to us this last slide here? You sent.
Basically, those are just four. Right. I put that there so we could see exactly, again, another example of signatures. The top one is a blank signature. The second one is a special endorsement. So the first one is a blank endorsement. The second one is a special endorsement. The third one is a special endorsement. The fourth one is a restrictive endorsement.
Deposit only, right.
And the last one is a special endorsement with restrictions.
Right.
You're given a special set of instructions, pay to the order of. And then you have a party named, and then you add an additional set of instructions without recourse. So now you're restricting what can be done.
Right. Right.
And
Right.
again, there's been so much word crafting by the banks.
Yes.
It's really hard for people to get their heads around this. So
really
when they say, well, this is bearer paper, no. If we went back to the first slides where it said pay to bearer, now that would constitute bearer paper.
Right.
So when it says pay to the order of, that is order paper.
Right.
But because you've been indoctrinated for decades and decades, and nobody has argued and stood up and said, you know what, you're wrong.
Right.
And that's what we're trying to do today, is to educate the people to stand up. All right? This is what is bearer paper.
Right.
Pay to bearer. This is order paper. Pay to the order of.
Right.
Now, for the last, 3-4 years, I have never seen a tangible promissory note that says pay to bearer.
Right.
There is either a named identified party or an unnamed unidentified party on a instrument that is incomplete.
Right. No
So
signature.
it's either one or the other.
Right. 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 This has been really great, Joe. We so thank you for this brief little webinar right now to bring us up to speed on really, and it's all about actually reading the real words and understanding what's said. I myself have seen my expertise and awareness expand just from looking at people's documents. I've been doing that now for 3 or 4 months, and what I didn't see in December last year, I now see at a glance because I know what it means when I see these words, and it will say, as attorney in fact, or just the titles that are used and who the beneficial rights are, quote, being assigned to. Now it's really obvious, but it wasn't obvious 4 months ago. It takes education like this. And Joe, we really thank you for bringing this to our attention.
Well, that's good. Again, the biggest myth we just need to disprove.
Absolutely. And I'm telling you, I'm not going to rest until we have a tremendous coalition of attorneys all around the country using these arguments successfully in court on behalf of homeowners. We just literally must stop this theft. And I thank you so much for being a part of it. Thanks, Joe.
All right, I will talk to you soon.
Okay.
All right.
And I'd like
Bye-bye.
Bye now. I'd like to welcome to the show Charles Wallshein. He's on the phone today. Charles, this is CJ. You're on the air.
Hi, CJ.
Hey, welcome to the show. I've got your picture up. So one of the first things I wanted to ask you about, I know you're expecting this, is about this article I saw in the newspaper. Somebody sent it to me online. It's about some judge sanctioning or chiding Judge Shack for a ruling and a reversal. So can you please explain what that's about and what I already know what you think about it, but everybody else wants to know too.
Yeah, sure. Yeah, I know know Judge Shack. He actually sits on my CLE panel out here. He's a brilliant jurist, and he's really gone out of his way to understand the securitization failure and the complex machinery of the securitization model and how it works in a foreclosure context. Now, you have to understand. I'm just going to try and set the scene for you a little bit.
Yes.
Is that most, and this is true for most jurists in the country, is that they really don't understand. I mean, they're still used to the old banking model where you have building on the corner with a teller and a vault and an Irish guy and a toaster. You know what I mean?
Exactly.
That's what they're used to. So when someone talks to them about a foreclosure in the context of them sitting on a bench, a judge sitting on a bench, and not really being out in the real world, understanding how these things work, they're making assumptions that you and I have known for years aren't true. We know that the entity that loaned the money didn't give out toasters and didn't have a vault and didn't have a teller. They were a mortgage bank.
Exactly.
We know that, and like everybody else, we take that for granted. Well, you know what? A lot of the judges don't know that. They say it's a bank, and if the loan has been assigned, they think it was done like the old days, where it was one bank, a real bank, with a toaster and a teller and a vault, to another bank with a toaster and a teller and a vault.
Exactly.
Both know that doesn't happen, and no one. And now you throw MERS, the mortgage electronic registration system, you throw that into the mix, and now you just lost everybody. There isn't. I guarantee you, there isn't 99 out of 100 judges out there at the trial level don't understand what this is all about.
Right.
So when attorneys, especially in this case, which was the
this was HSBC.
which is very popular case. So in 2009, the hearing was held, which is like 3-4 years ago.
Right.
What happened is you get one of these bank attorneys standing in front of Justice Shack and giving him a load of malarkey, and see, but Shack already knows that this is a load of malarkey. So what does Judge Shack do? He pops a cork because he knows the truth and he knows he's getting lied to.
Right.
And he would react the same way pretty much any other judge who knew that he was being lied to would react. He popped the cork.
Right.
Mine. Oh yeah, if I'm wearing robes and this is what I do, I'm a civil servant with an oath to make sure that sort of relating back to what we spoke about last time, that my courtroom is a place where the truth comes out, and you have an attorney show up and lie right to your face, you lose your mind.
Exactly.
Which is what he did. He said, "What are you doing?" It was just a bunch. Basically, they just weren't telling the truth because Judge Shack has educated himself.
Right.
He knew that he was getting lied to. Most of these other judges don't even know.
And so you don't really think it's a conspiracy or that they're corrupt. You think mostly they just don't understand it.
Yeah, of course they don't understand. The judge is corrupt. Every judge in the country, is corrupt. No, please, don't even. I'm a lawyer. I can't even hear that.
Right.
I can't. I mean, you may not agree with them. That doesn't mean that they're on the take from Wall Street. That is absurd.
Right.
That is absurd. They just don't understand what's going on because they don't. This is, I was on Wall Street for many years, and I understand how this process works. And then I practiced law doing this for, now that it's become popular, I guess 5-6 years, really knowing what's going on with securitization failure and how it works in the foreclosure context. And I'm one of the few people that really understand that. And I understand it to the point where I can teach it.
Yeah.
To bring it to a judge's attention, it's like, this is what you think, and this is the way it really is.
Right.
And, that's the way I write my paper. So I have this, if I write a 30 or 40-page brief or a memo, probably the first 10 pages is I'm setting the scene.
Right.
And I'm not looking to make them experts. I'm just to disabuse them of the things that they have come to know or think that's the way banking is done today, because it's not.
Well, and it's just like what Joe was explaining about bearer paper and pay to the order of. All these assumptions that everyone is working with, including like the friend he mentioned last Friday who saw the assignment in the paper file on the desk, but the assignment was never recorded. And so as far as the friend was concerned, that was a valid assignment. But, of course, according to the law, it's not, because it wasn't recorded. And this is just an expansion of that, is what I hear you explaining to us.
So getting back to this Payer decision, what he did is I think Judge Shack was so disturbed by this, is that he did two things wrong. And I think I put it in an email to you when you asked for my opinion of it.
Yeah.
He dismissed the case with prejudice, which you're really not supposed to do. You have to give the plaintiff, what's the plaintiff here, the bank here, another chance to come back and, I don't know, maybe call LPS and have a bunch of new documents made up for $9 a piece or something like that, and come back with other set of documents that might look right this time.
Yeah, forge some
in
more.
reality, how many times can the same plaintiff come back and pleading the same case with the same misrepresent
I know.
documents?
I know. If you're gonna
I
forge,
try to never use the word fraud. Such a terrible word.
yes.
Because it's like criminal misrepresent. You got to give the other guy the benefit of the doubt. Everybody knows what we mean, but I use the word misrepresent, and
Right.
I really don't like to use the word fraud.
But if they're going to misrepresent the first time, then like I call it my doctrine: once a cheater, always a cheater. Once a liar, always a liar. How can you trust them once they've been proven to be lying?
Listen, the only way that any of this is going to change, CJ, is that if every judge and every lawyer, every judge gets to hear it from a lawyer who knows what he's talking about, or she knows what she's
Right.
talking about.
Right.
It's the only way it's going to change. And the legal strategies involved, well, that sort of comes second, because this has to be put out in sort of a vernacular where every attorney has to really put that whole securitization stuff and the complexity of a securitized transaction, and really put that off to the side, because the only thing you have to know about a securitization is what should have happened and the parties that should have been involved.
Right.
And you look at the the pooling and servicing agreement, say this is what should have happened. You look at the public record, say this is what did happen.
Right.
This is how it destroys standing, because all of these cases are about standing. Because I walk in sort of like arrogant, and I say, my attitude is to these attorneys that are standing in front of a judge with me is, who the hell are you and what the hell are you doing here?
Right.
I am never on my heels.
Right.
I am literally at their throat from the minute I walk in, because I know what happened.
Exactly.
I know what should have happened, and I know I can put it in plain English, so a judge who doesn't know anything more about the securitized transaction, he still thinks he's dealing like with an Irish guy and a teller and a toaster and a vault.
Right.
And I tell him this story about Wall Street and sellers and depositors and collateral assignments and MERS, and I tell stories about it, and they look at me like I just rode into the courtroom on a unicorn.
I'm sure they did. It's like, what are you talking? And I'm telling you,
it's way different when I'm leaving.
and see,
Education.
and this is what I experience when people, like one of the first times that I interacted with a person in Mendocino County, it happened to be a retired real estate broker from San Francisco. And I'm a real estate broker. And this was a couple of years ago. And she was working to help people try to, stop foreclosure and keep their homes. And so we got connected, and I started to explain to her what the market was like and what we were doing. And she just stopped me and she said, "This is a foreign language. What are you talking about?" And she's been a broker for 25 years, and it's just completely upside down. And that's exactly what you're talking about in law and in this securitization effort. It's just completely upside down from the way it used to be. And why would anyone know unless they're involved in it? And that makes good sense.
In title theory states, because one thing that nobody knows in title theory states is how to defend the foreclosure, because no one ever had to.
That's
it was
right.
open and shut. The entity that loaned the money on day one is usually the entity that's taken the house back.
Right. That's the way it used to work.
In a foreclosure sale.
That's right.
And there was no judicial proceeding.
Exactly.
Right. So why would anybody in California, or Texas, or Arizona, or Massachusetts have any idea on how to actually defend the foreclosure when nobody in the state ever had to know how to do it, or a judge ever sitting in front of a judicial foreclosure, because there were never any.
That's right.
There never were, and there aren't now.
That's
but
right.
the principles that from a state like mine, a state like New York and New Jersey, the principles that apply in a judicial foreclosure, understanding the documents and how standing is destroyed by these falsely created, see, I'm not using that F word, right? I'm using the word falsely created or misrepresented documents.
These fake.
Create the chain of title from the lender to the foreclosing entity.
Yes.
That's stuff that you learn if that's second nature. That's just the way I think, because I'm in a judicial jurisdiction.
Right. Right.
So what you mentioned, I'm going to be out in California. I'm dying to come out to California.
Absolutely.
To get a small army of people together to really teach them about what it's like to be me.
Exactly. Exactly.
Well, because you can't learn. I don't think it's easy to learn how to defend a foreclosure if you're thinking about it from a title theory perspective.
Right.
I really want to teach the people in the title theory states what it's like to understand the chain of title if you are in fact in a judicial state.
Right.
Where it's litigating the chain of title, because that's really what it's going to come down to. Because once you can demonstrate a break in the chain of title, you can really understand. What the standing issue is, because everything that I do, it's all about standing. Nothing more, nothing less.
Right.
Who are you, and what the hell are you doing here?
Exactly.
But that is my posture. And
right.
I come right at them.
Right.
But let me tell you something. They don't even know. What you doing here? Okay,
exactly.
You borrowed from A. There's somebody else. There's somebody on the, like whoever, like some Deutsche Bank trust or something like that.
Right.
2005-C6.
Yeah.
They're the plaintiff. This is my state. And then the person had been paying some servicing agent for the past, year or 2 years, and it's the fifth one. They changed their servicing agents like you and I change our underwear.
Right. Right.
So you're telling me, and this is what I say, you're telling me that anybody knows where this loan is. So I say to them, who the hell are you, and what the hell are you doing here?
And then they go, what?
Oh, don't know. I put them right back on their heels.
Right. Right. Yeah. This is truly the attitude and the facts to back it up that the people in every state want. Because I'm telling you, Charles, it's not just judicial and non-judicial states. I've got that map up right now so people can understand. They can look to see which state they're in. If you're blue, that's a judicial. And if you're in a gray state, that's a deed of trust, a non-judicial, or like Charles keeps talking about, a title theory state. And the fact of the matter is, it doesn't really matter, Charles. There are so few attorneys that really get it or even have a good understanding of how to draft the lawsuit or to pull in the correct facts and make the correct or the solid pleadings so that you could get good rulings out of it. And so now we've had 3 or 4 years of bad rulings that have to be overcome in many places.
Well, that's where every state started. Every jurisdiction started with nobody understanding anything.
Yeah.
And what it's going to come right down to is a basic understanding of agency law, which is pretty much the same in any jurisdiction. A principal has the power. The agent acts on the direction of the principal. An agent, like MERS, can never have more authority than its principal.
Right.
And that's just the way it is. That's all 50 states. An agent cannot act independently of its principal under any circumstances.
And yet you could argue that MERS does a lot, right? I'm thinking of the assignments and all that kind of stuff I've seen.
Say, well, they act as the nominee for all successors and assigns. Well, let me, what I say to some judge said that to me here, and I said, okay, Your Honor, how do you become a successor or assign? You need an assignment, right? If the assignment is invalid because it's robo-signed or it's fraudulent or whatever you want to call it,
that's right.
then there's no assignment. Now you can't be a successor and assign.
Exactly.
You can't be an assign until it's assigned to you. And if
Legally.
the assignment's a phony, guess what? You're not an assign.
Exactly.
Basic logic. It's not like a second grader can figure this out.
Right. Once you know where to look. And that's what we've been talking about. Looking and really understanding what they did and how it applies in the law, and then how to take those facts and get the results we want in the legal arena.
CJ, one thing I want people to be really careful of, is I've been hearing a lot of chit chat.
Yeah.
About, what do you call it? A quiet title.
Yes.
It's absolute nonsense. You're not nobody's quieting titles. The quiet title is the last thing that happens. Is once you can demonstrate that there is absolutely no way to figure out the entity that owns the beneficial right to collect money and enforce a lien.
Right.
In other words, the rights under the note and the deed of trust.
Right.
Once the court reasons to that point, you bring a declaratory judgment for who the hell owns my note. Who owns the loan? And that's not a quiet title. That's a declaratory judgment, because you really don't have a quiet title is when you have competing interests in the same interest in real estate. That's a quiet title. It's like, you can picture two people making noise, now they got to be quiet.
Right, and you got to pick one or the other.
Now there aren't two people. There's just
right.
There's the homeowner isn't a mortgagee, but the mortgagee or the entity holding the deed of trust, we'll just call him the mortgagee for now.
Yeah.
They're the mortgagee. So it's not, you don't have a competing interest, but they can't prove that they are.
Right.
And there are equitable procedures, like what happens if all the paperwork was lost?
Right.
There would be some equitable proceeding in the state to recreate the documents through what they call parallel evidence. Right? If there was money given, you can't deny that. Here's a canceled check. The homeowner,
exactly.
But it's a matter of who can enforce the lien, who can enforce the deed of trust. That's what this is about.
Right. And so on a
God forbid it's the wrong entity.
Well, and that is the point, and that's the point I'm making all the time.
A client walked in 2 days ago. I think it was last Wednesday or Thursday. I think it was Thursday. And there were two entities for a while foreclosing the same mortgage, not the same house, the same mortgage. Now you tell me how that happens. No, keep in mind at the same time. It's not like one and then the other one assigned the action. No. There were two actions, two different index numbers pending on the same mortgage at the same time. Two completely separate entities. It's not the same entity filed twice by accident. Two completely separate entities foreclosing the same exact mortgage. Now, you explain that one to me.
Well, and you explain to me then how somebody can pay off their loan and then get foreclosed. This is happening too.
Oh, no, I can explain it.
I know.
No, I can explain it. And
okay.
And by the way, finding the documentary record of how that happens is not difficult. You can find the documents. They're available. And you don't have to be one of these, you don't have to spend $3,000 or $4,000 for one of these, certifications or anything. It really, you can get lost in the details. At some point, you're not going to be able to see the forest through the trees anymore.
Right.
What you need to do is you need to know how to make a record. Because if you figure, well, here's my assumption, that the appellate level in your state is probably a whole lot better than the trial level.
Probably.
They have a better chance of getting it. So the only thing that an appellate court can hear is what has been put into the record at the trial level. So even if you walk into court at the trial level, at whatever level of proceedings that you have to bring, you're going to make a record. You're going to bring so what are you looking for? You're looking for reversible error and abuse of discretion.
Right.
And once you can show that, then the case gets sent back down to the trial court by your court of appellate review, and you're going to have a hearing for accurate determination of the facts. And that's what it's about, making a record. And boy, let me tell you something, it's not easy. Especially, and I guarantee it, nobody in your state knows how to do that, because no one ever had to. They don't teach it to you in law school. They don't teach it, you don't get any practical experience as an attorney doing it. Nobody knows how to make a record in a foreclosure proceeding, which is all I do here. So
Right. And how to
Well,
get
where
that
you,
done.
Yeah, so it's like,
Yeah.
well, whatever. You can't bring somebody from a title theory state in to teach you that. You got to bring somebody in from like me, from a lien theory state,
That's
where
right.
where it's an equitable proceeding and property is transferred by court order.
Right. Right.
That's the way it goes.
So Charles.
The way I'm not looking to disparage anybody.
No, I
trying
understand.
to teach this from a non-judicial jurisdiction's perspective because it's important. And the truth is, I don't know every California statute, but it's got to be pretty much the same as every other title theory state.
Absolutely. Absolutely.
Yeah, which I'm
Absolutely.
very familiar with Massachusetts. I'm very familiar with Arizona's and Texas.
Yep. And I've already found the statute that basically states if the assignment giving the entity the authority to foreclose is not recorded prior to the notice of default, then the NOD is void. And that happens, 30% of the time on the 18 that I analyzed? I mean, the fact is that the statutes are not that hard to find or understand once it's explained or we're pointed in the right direction. It's the whole strategy, like you're talking about, of shifting the burden and having the facts in advance so that you can get them on the record. And so let's say that the owner is in a lawsuit, represented by like yourself or someone in California licensed to practice law that follows a strategy and gets to that point in that lawsuit that you talked about, the declaratory judgment. What is that? Does that mean that judge then deletes, vacates the lien and the notice of default? What does that mean? What is a declaratory judgment?
A declaratory judgment, which is really what you'd want, is really what a person would ask for, is basically it's a type of relief where a judge has to say, what you'd be asking for is who owns my loan.
Right. And when they can't say who owns it, then what happens?
Well, it's kind of done. It's not really done that way here.
Oh, okay.
Because you ever hear the expression that you don't ever ask a question that you don't know the answer to?
Yes. Well, I ask them all the time, but of course.
No, I don't know the answer to that.
Right.
But what I can
Right.
say is, yeah, we borrowed money, but we didn't borrow money from you.
Right.
And there's no way you can prove it.
Right. And so what is the end result then? Is that just a stalemate, or what happens?
Well, it seems to be a stalemate. So far, it's a stalemate. I mean, in this state, what happens once you lose summary judgment? When it's the law of the case that all the evidence that you put in does not make a prima facie case. What happens then? If you're a bank or a bank's attorney, and you can't, and every document that has been from the beginning that you by the way have sworn to its accuracy and veracity and authenticity. What happens when the judge says none of that's real? Where do you go then? What do you call LPS and get them to make up a bunch of new docs? What do you do?
And so what are the banks doing?
You got me. They ain't doing anything from what I can see. They go home with their tail between the legs, and I guess they take one for the team.
And so then the house. Okay, so then the owner they're in some kind of limbo land?
Hey, listen, CJ. You know the theory of low hanging fruit. Once you
Yes.
break their chops bad enough, and you are no longer low hanging fruit,
Right.
they're gonna go after somebody else.
Right.
Yeah, you start hammering away at them. They're gonna say, you know something, this one is too. It cost them more to foreclose than
Right.
than the house is worth.
Right.
So they go somewhere else. They go to your neighbor. They go foreclose on him. They leave you alone. I mean, if you were hungry and there's you're
Yeah.
a mango tree, do you jump up to the top branch? You pick the ones that are 4 feet off the ground.
Right.
Right. That's it.
Exactly. Is there some way to end it, so that the owner can, go back to normal?
When judges, yeah, end one proceeding? Yeah. No, you basically tell them I'm going to live here the rest of my life, and you're going to pay my taxes. Thank you very much. You'll have.
Well, see, and this goes to the next question, and
That's what I tell them.
well, the real issue is, let's say that the owner has to sell, And so now they're stuck, right? Because they still have.
They have to sell.
Well, they have to move or something. I mean,
I don't know. On the way out, I guess you stop by the local Bank of America, open the door, and flip them the keys. Go through the drive-through, throw it in one of those cups that you hit the suction button, you hit the green button, it goes flying up, and thanks, so you have a nice day. Yeah, I'm done. Oh, and
Right.
you can fix the hole in the roof.
right,
Yeah.
right.
I don't know. I don't know where this ends, but I'll tell you
Yeah.
one thing: you don't roll over. You don't roll over and let these people beat you up and call you a deadbeat.
Right, and then take the house and
Yeah, right. You walk into court, and as soon as they look at you, you punch them right in the teeth.
I know, we're street fighters, Charles. I do identify with that. Oh, this has been good.
My judges, they say, "Oh, your client's a deadbeat." I'm like, "Deadbeat? Try that again. Say it again, pal."
Get that on the record.
But I tell the judge that I'm not even sure my client ever defaulted.
Right.
I had a client walk into my office today, one of our favorite servicers, one I can't stand the most. The modification. They're adding. You have to see the way the statement is written. They're saying that she owes $500 more than her principal and interest, taxes and insurance. And I don't know how that happens.
That happens all
Sent
the
her a
time.
statement. No, she's paid 5 payments, and they have her delinquent. They have her delinquent 5 payments, and I'm looking at certified checks and withdrawals out of her
Yes.
out of her account for the money that she said she paid, and she did pay it. I'm looking at it; it's right there.
Yep.
But it's not being credited on
That's-
the lender side. In the servicer's account, it's not being credited. And they sent her she got her statement from for the loan servicer, and she's not credited with those 5 payments. Now, what does that sound like to you? Sound like she defaulted? But I guarantee you give her enough time. After chit-chatting, talking to 9 different people on the phone, never getting the same person twice. Oh, I'm sorry, we lost your paperwork. I'm sorry, we don't accept emails. Oh, I'm sorry, we never got your letter. I'm sorry. And she's going to get the default notice.
Yeah,
She's
absolutely.
She's going to have an accurate record of every conversation.
Yes.
It's going to be memorialized in a letter.
Right.
She has every statement, everything. So if anybody ever, and I have a lot of clients like that.
Exactly. It's because
You
they're
defaulted. No.
they're
Wrongful
pushing them.
default.
The servicers are pushing people into foreclosure.
Yeah,
Even if
well-
they get the payments on time, they won't credit them on time so that they'll be late.
Yeah, you tell me something I don't know.
Yeah, exactly. Exactly. And that's what this country doesn't really understand. They don't understand that
I
this
don't understand
it's
that
broken.
this is not an Irish guy and a toaster and a vault and a teller. That's the first thing they don't understand.
That's right. That's right.
That there's no motivation, that the securitized transaction is that the way RMBS loans are serviced, there is an inherent conflict of interest between the servicer
That's
and
right.
the certificate holders that
That's
causes the loan servicer with upside down homes.
Yes.
The servicer's never going to get the servicers. The entities that tell the servicers what to do, which is the weakest, and this is why to understand the securitization is actually important, because you have to understand why there's an inherent conflict of interest, why the servicing agents it's so counterintuitive to believe that a servicing agent, if you're giving them something, it's not it's not better than, they don't think it's better than nothing. They think nothing is better than something.
Right.
So counterintuitive. Yeah, it's like this is the Twilight Zone, but it's
Exactly.
not. If you really understand how structured finance works in an RMBS, it makes perfect sense.
Right. Right. But it's completely
I,
backwards.
by the way, have gotten through to a very large part of the judiciary here that nobody's pulling the wool over their eyes.
Anymore.
They're not. Yeah, they're not in that world of that Twilight Zone counterintuition. This doesn't make sense to me. It makes perfect sense.
Right.
The,
Right.
the lies aren't mistakes; they're lies.
That's right.
Right? Yeah, that's what I have here in New York. But whatever. This is. I spent 2 years teaching people and standing up on a soapbox and screaming at the top of my lungs, and I'm called arrogant and every name but a child of God. Let me tell you something. People are getting it.
Right.
And there's
Right.
a small army of Charlies out here
Right.
that are hammering away at the judiciary and the plaintiffs' lawyers. And guess what? The tide's turning, and I'm going to come out to California. I'm going to go to Arizona. I'll go to Hawaii. Go anywhere they need me, and I will start doing it there.
Exactly.
Not rocket science.
Exactly.
Pure common sense, but you can't learn it from someone who doesn't know how to do it.
Exactly.
You have to come from a lien theory jurisdiction to teach two things: burden shifting.
Right.
Burden shifting, and you also have to teach the chain of title.
Right. Right. And then how to draft that so that you get the good rulings that you want down the road.
Well, you have listen. If there's no action, right? If in a title theory jurisdiction, if there's no action, you're not bringing in action. It's like like having the pawn shop sell, your guitar or whatever it is.
Right.
Because that's what they're really doing.
That's right.
When you load, it's like having your house in a pawn shop.
Right.
Title theory jurisdiction.
They just sell it.
Sale. See you later.
That's right. That's right. You have no recourse.
Well, no, there's no. How do you have to first bring the type of action where you can shift the burden.
Right.
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 And that is a judicial theory jurisdiction type of mentality.
Mindset. That's right.
Yeah, you can't dream this up. You were taught. I was taught, right? I was taught from the beginning.
Right. Right.
I knew from the beginning. So, for me, this title theory stuff was, when I heard about it made perfect sense because it's power of sale. It's like a UCC sale.
That's right. That's right.
Yeah.
And it is. And it's just horrific. And the people are just getting shoved out of their homes, kicking and screaming.
Listen, I'll come out there. I'll teach a bunch of these weekend things. And
yeah.
whatever. Yeah, you'll see things turn around.
Well, we so thank you for joining us today, and we look forward to getting some seminars out here and all over the country on a schedule, set weekends. We're working on that right now behind the scenes, trying to make this happen.
Sure.
So thanks, Charles. We just
I'm
so
good to go.
appreciate it. So are we. So come on, guys. Those of you watching, let's get some venues set up, and Charles is going to come out and teach. We so appreciate your sharing today.
I love you, CJ. You're the best.
You too. Together, let's make this happen around the country. The people are desperate, and the media's blacked out. So we're working on trying to make this a big event that the media can't cover up. We're going to let our lights shine. Thanks. We'll talk to you later, Charles.
Bye, CJ.
Bye now. And that's it for today. We just appreciate you being patient with us on the little audio thing we had, and I'm going to fix that. We'll see you tomorrow. Thanks, guys.
When I was a lass, I was proud of me class, like my father and mother before me. They taught me to fight for my civil rights, but it's always the same old story. The rich reign supreme while the poor can but dream of the Labour or Liberal or Tory. And I say, bugger the bankers and politicians, bugger the bureaucrats too, bugger the buggers who make up the rules. And if you're one of them, bugger you. And if you're one of them, bugger you.
The system is bent and the money's all spent. We're measured from every direction. The workers get taxed while the wealthy relax.
With nary a moment's reflection. When it's grass, there's muck, and they don't give an arse, 'cause we're programmed against insurrection. And I say, bugger the bankers and politicians, bugger the bureaucrats too, bugger the buggers who make up the rules. And if you're one of them, don't give up the struggle for justice. But I've done my time on the protesters' line, and these days I show my dissent